All right, so what I want to cover today is some fair housing laws news. And while that's normally a really bad idea for anyone launching a new channel, as these are not videos that tend to get many subscribers, I thought this one on the federal government putting forward a rule that will allow them to start hiring ex-felons to act as fair housing testers. Having a big property management company, I've held a number of professional landlord designations. And when I first was getting trained, the rule about criminal records was don't make exceptions and have a very firm policy you apply across the board, because what can happen is that when you get real subjective about what kind of criminal record you would work with, then somebody in a protected class, if they're denied, but somebody who's not in a protected class got the rental instead, but also had a criminal record, then they could argue, for all I know, it was based on my protected class rather than the overall merits of my application, which there's some sound logic there, regardless of how much we might agree with it. Now, a court ruling has determined that I'm going to try to put this as concisely as possible, which is not my strong point. But what the court found was that even though criminal record is not a protected class, and we will go over what the protected classes are here shortly, but even though there's no such thing as being discriminated against because of your criminal record, that when landlords deny people with overbroad criminal record requirements, then that is by default a way of discriminating against people in protected classes, because certain minorities are disproportionately affected by having to go through the criminal justice system. All right, I want to quickly touch on, just for anyone who doesn't know, what is a protected class under the fair housing laws. So here we can see federal fair housing laws prohibit discrimination in housing related transactions based on race, color, national origin, religion, sex, which includes sexual orientation, and gender identity, which has also evolved from court precedents, and familial status. So if you have a bedroom occupancy of 2 per bedroom, then it would be illegal to say I will only rent to a married couple, but not a single couple. And disability, which hopefully is pretty self-evident. All right. And then also, in addition, many states and local jurisdictions will have additional classes that will increase these protections for various subclasses. Let's go ahead and jump right into the mud here. Exactly what does a landlord need to understand about this when they are processing applications? There are many circumstances where you can deny someone based on their criminal record, but we can no longer have blanket bans. Instead, we need to make specific bans that under this are discriminating, and it's really tough to pinpoint exactly what a compliant fair housing laws policy for criminal records looks like at this point, but I'm going to do my best here. So I'm still here at the Housing Center Org guidebook, which once again, link in the video. It says, in regards to the use of criminal history, here's what landlords cannot do: denying housing based on arrest records. Hopefully you're aware that just because someone is arrested, they're absolutely, under our Constitution, which I happen to be a big supporter of, does not mean they are guilty of a crime. They are only convicted when they're found guilty by a jury of their peers, or they plead out or whatever and get an actual conviction. So here, where historically the same logic applied to arrest records, that is, as a landlord, and I'll just tell you a personal anecdote, that back in 2006, I had a affordable rental apartment complex. I put in place a policy limiting people on any arrest for drug crimes in the last 3 years. And true story, when a lady came to me and over the course of the last year had been arrested over 6 times for possession or distribution of crack cocaine, but no convictions, and some of those were open cases, I was able to say, I, across the board, simply do not rent to people that have these type of arrest records. That is now prohibited. Also, placing blanket bans on renting to anyone with a criminal history, that includes felonies. You can no longer tell potential applicants we don't rent to felons. So blanket bans are bans that apply to or affect all or the majority of a given class of people. I'm not sure how to interpret that in this context. Conducting background checks inconsistently, performing them on some and not on others based on stereotypes or fear. I will tell you that if this stuff goes to court, the prospective tenant is not the one that has to prove the landlord intended to discriminate. The landlord has to prove that they didn't intend to discriminate, which just imagine what that might entail. How do you prove it? Conducting background checks inconsistently, performing them on some and not others based on stereotypes or fears. That's just good common sense, and that's good business. Everyone gets the same application process. You absolutely should not be doing applications based on any stereotype of someone, particularly involving a protected class that I just discussed. Here it goes on further, a landlord must consider individuals on a case-by-case basis and evaluate the nature and severity of the crime and consider the length of time that has passed since that crime was committed. This one, I gotta be honest, makes my head spin. They're literally asking me to judge a person's criminal record and then be sure that I am not wittingly or unwittingly being discriminatory based on it. So if they find my decision making to be unreasonable, then I am liable. And this just gets more confusing. A person can be denied based on their criminal record legally if their recent criminal record makes them dangerous and a risk to other tenants or neighbors. Denial must be based on reliable evidence and not be hypothetical or speculative. So I need a evidence-based policy. I'm definitely thinking we're going to need a good policy made by an attorney-led organization for this. As you can see here, provide evidence proving that the housing provider has substantial, legitimate, non-discriminatory interests supporting the housing denial. That is going to be really challenging to establish. So we're going to have to find a solution for this. And here, show that the housing policy accurately distinguishes between criminal conduct that indicates a demonstrable risk to resident safety / property and criminal conduct that does not. So we have to be able to show when we're making this decision, it's a threat to property or safety. So here I want to note that the only two clear things it seems like we can always reject tenants for is if they are, I want to be careful with how I say it, for a sexually oriented offense in any state, and applicants convicted of manufacturing methamphetamine on federally assisted property. So there's no time limit for that. But that would be your manufacturing meth in Section 8 housing versus in a private rental. So I guess in theory, I can't discriminate against anyone who a long time ago, whatever that means, manufactured methamphetamine in their own apartment they were renting, but I can if it was a federally assisted apartment. I just work here, guys. And I do want to go ahead and comment on this one because this is one that has not changed since I first got in the real estate industry, but that many landlords, non-real estate professional landlords, the biggest trap I used to see them fall into was discriminating against people for a history of drug abuse. So it used to be that we could deny someone for a drug related conviction, but it's always been that being in recovery from substance abuse is a federally protected status. So if someone came to me and I said, you didn't list your landlord reference from 6 months ago, and they were to say, that's because I was in a 6-month drug rehab, then the correct answer is, oh, okay, cool, got it. And that would absolutely be a violation if I were to hold the fact that they were in any way seeking medical or therapeutic help for their disability, which is being in recovery, not active drug use or controlled substance use, but being in recovery from substance abuse. All right, so here's a little case law. A landlord in October of 2019 settled a discrimination case against them for nearly 1.2 million, and that was a settlement. Imagine that if they didn't settle, how high that judgment could have been. And basically, what happened was the Sandcastle Housing Towers development refused to rent apartments to them. So these were testers. These were people on behalf of a nonprofit just going again and again, building a case. And they just kept telling all the applicants that they have a policy of prohibiting anyone with a criminal record from living there. And so by just holding that position, which once again, back in the day, wouldn't have been a problem. In fact, it would have been a good policy because that's a uniform decision that you're applying equally to any applicant, regardless of their protected class. That would have been a good policy. Now it got them a $1.2 million judgment. And then another one against Sailboat Bay, where their leasing agent repeatedly discouraged testers who were coming in. Yeah, don't bother applying. You're going to be denied if you have a criminal record or arrest record, just for the statements that the leasing agent was making. And these leasing agents are often getting paid $15 an hour. The Sailboat Bay agreed to pay $35,000 and agreed to new policy drafted by HUD and LA Fair Housing Authority. And then the number of pending lawsuits. All right, so here I am on a HUD memo about this issue. And here, section 3, this is what I had stated earlier, but I'll just read it right from the memo. A housing provider violates the Fair Housing Act when the provider's policy or practice has an unjustified discriminatory effect, even when the provider had no intent to discriminate. Under this standard, a facially neutral policy or practice that has a discriminatory effect violates the act if it is not supported by a legally sufficient justification. And here again from the HUD memo, a housing provider with a policy or practice of excluding individuals because of one or more prior arrests without any convictions cannot satisfy its burden of showing that such policy or practice is necessary to achieve a substantial, legitimate, non-discriminatory interest. And I already stated the reasoning behind this earlier in the video, but it does cite the Supreme Court's opinion on it. So that's going to be the law of the land moving forward. And here in the conclusion, HUD sums it up by saying, I'll read a quote here, where a policy or practice excludes individuals with only certain types of convictions, which is what they want us to do, a housing provider will still bear the burden of proving that any discriminatory effect caused by such policy or practice is justified. Such a determination must be made on a case-by-case basis. So we're left with no clear guidance here. Even if we were to use something that attorney drafted for a large multifamily housing development, and a court found it to be non-discriminatory, but we took it and we applied it to our own screening process. A court could still say that might have been fine for them, but your situation over here is different, so you are liable. All right, so this is the solution part, and unfortunately, like a lot of the other challenging issues I try to tackle on my channel, this is pretty much as good as it gets for the solution. I'm going to be doing a follow-up video about a better solution, but this was, sad to say, one of the better articles on how to go about screening tenants when it comes to criminal record. And I'm on Doorloop's website, and it's giving us the do's and don'ts. Take care when drawing U.S. criminal record policies, ensuring they cannot be seen as discriminatory. No kidding. Make sure you're looking at the nature, seriousness, and reason for the criminal record before denying a person housing. A one-time drug possession might not be grounds for denial. For example, who's writing this? Never mind. Ensure that when you reject someone's application based on their criminal records, you do so because they present a risk to the safety of others. And as I showed you with the HUD memo and some of the other material I've reviewed, you have to be able to prove that if you're challenged, which is really tough. Consider how much time has passed since the crime was committed. I haven't found anyone giving guidance on what's reasonable in that arena. And ensure that all applicants are treated fairly regardless of whether they fall under a protected class or not. That's pretty much just what the fair housing laws are. And be sure to familiarize yourself with the law and regulations in play. Okay, you know what? On a helpfulness scale, I find this article at a 2 on a 10-point scale. Doorloop is outranking my website, naplesed.com, and this is what they have on it. Sorry, I'm just going to get back to it. Avoid broad or unclear policies, and don't treat applicants differently if they have a criminal record. Okay, I don't think we're going to get many solutions here. Let me see if I can find anything else. Outranking me. This is how hard it is to find guidance on this topic. I'm trying to find better resources. I did try when I was preparing, and at the very top of my Google results, here's that stupid Doorloop article. I've hopped over to Nolo, which is like a legal aggregator for attorneys, to get a lawyer's perspective on this, and this was one of the top rated results. And here someone asked, I was rejected because of a felony from 10 years ago. All they wrote in rejection was the word criminal. And the answer for the question, yes, it's a form of discrimination, but unfortunately, in all likelihood, you have no legal protection against discrimination based on your criminal record. That was what the whole video was about, that this is not the case. And I've been suggesting this is a matter for the attorneys. There we have it. All right, so here our attorney resource was just flat out wrong. I'm going to keep a look. All right, so an otherwise really tacky article on the subject referred me back to this memo. I would say that having reviewed the entire memo myself, it's probably going to give you the best idea of how to go about crafting a policy. I could not see most landlords wanting to try to tackle this. All right, so this is probably the best article I have found. I'm going to put it in the video description. It's from the law firm. I have no idea who this law firm is. They're apparently Wisconsin-based. Kramer, Elkins, and Watt, LLC. I'm not even going to get into, because what they say is the same stuff we've been going over this whole video. Basically, I guess in conclusion here, definitely do not have a blanket ban based on criminal convictions. On the one hand, it's telling us focusing on violence and property damage is more likely to be found as necessary for resident safety. We as landlords have to make a judgment, hopefully with the guidance of our attorney. I've also been reading that drug convictions, especially distribution, sale of a controlled substance, can be used as grounds outside of the lifetime ban for if you manufacture meth in federal government subsidized property, that you can use that. We're not left with a lot of clear guidance. I definitely have very carefully crafted policies factoring all this in. I am not an attorney, and so I am not going to publish those policies or get into my own policies here. But hopefully this has given you some insight and definitely given you some stuff you can't do and some good suggestions for how you might begin to proceed to make sure that your housing policy or your application process is not discriminatory in any way. We, of course, want to genuinely, sincerely want to make sure we're not being discriminatory in any way. It's my hang up is with the convoluted nature of the implications of the court rulings about this matter and how to apply them. I don't know. If you have any ideas or resources, I'd love to see them in the video description. If you made it this far, God bless you. Even I'm falling asleep as I finish this up. Please subscribe. Give me a thumbs up. I will be releasing a follow-up video once I get clear guidance on how to proceed with this screening of rental applicants in regards to their criminal background on the application.